All right, folks. Back by popular demand today, we have a review of this particular article. Okay, we're going to go through, highlight a few things, and talk about federalism as it applies to uh, this particular article. Okay, so the first thing this article does is it walks you through federalism. Is the allocation of power between the national government and the states. Okay, and this kind of goes along with what we're talking about. Remember, ultimately, what we want to be looking at is anytime a government, whether it's the national government or state government, makes a law, we want to ask who gets the authority to make that law. All right. And so you see here in the second question, it says ultimately the question is what should be the scope of federal power and to what extent should the existence of states be a limit upon it? All right. So this guy's asking, hey, what should the federal government be allowed to do or not be allowed to do? All right. And here's his thesis for this particular article. Okay. In this instance, he is saying, hey, I believe that the progressive vision should be, as it has been throughout history, to broadly define the scope of power to deal with society's most serious needs. All right. If he's saying that the scope of federal power should be broad, that means that he believes the federal government or the national government needs more authority than what most people would want to see it have. And he says they need that broad authority, that wide authority to deal with society's most serious problems. So he says, look, it's not that he hates the Constitution or doesn't want state governments to have authority, but he says the national government needs this authority to deal with society's problems. Okay? He says states don't have the ability to do with it. So let's make a little annotation over here, if you will. Uh, Federal government needs broad power. Of course, it helps if I spell things correctly. To deal with society's problems because states can't do it, meaning states don't have the ability. It's not that they shouldn't have the authority to do it, but they won't do it, right? It says this is in sharp contrast to the conservative vision of federalism. Since the country's earliest days, states' rights has been used by conservatives as a political argument in support of conservative causes. In the early 20th century, federalism was the basis for challenging federal laws regulating child labor, imposing minimum wage, and protecting consumers. Excuse me. During the Depression, conservatives objected to Franklin Roosevelt's proposals such as Social Security on the grounds that it usurped or took on functions properly left to the states. Okay? Now remember, this is federalism's always about an argument between who has the authority to do it, the national government or the states. Okay? And this guy says, hey, people who are conservatives, all right, they have always gotten in the way of progress in society because they said, look, when laws about child labor or minimum wage or consumer protection came up, they said, well, the national government doesn't have the authority to make these laws simply because it's not in the Constitution. And during the Great Depression, conservatives objected to Franklin Roosevelt's proposals such as Social Security on the grounds that they usurped or took away functions left to the states. So what they're saying is, hey, the conservative view is that the state government should have broad authority, okay? That states should have the authority. But remember, his thesis is it's the national government that needs authority, okay? So he says, look, during the 1950s and 60s, people objected to civil rights laws, saying that like Southerners challenged Supreme Court decisions mandating desegregation because not that they were desirable practices, but it's up to states to do that. All right. And so if you look at these, people objected to these laws simply because they said, look, it's not that I'm a racist or I want segregated schools, but there's nothing about schools and integration in the Constitution, so it should be left up to the individual states. And you don't have to highlight necessarily in here, but we'll make an annotation available that uh, proponents, that's a good word, proponents of strong state governments believe that we should strictly interpret the 10th Amendment. Okay? And if you remember, the 10th Amendment says any powers not given to the national government belong to the states. Okay? And he says, look, this is a problem in society because if you left, like the author says, look, if you left everything up to the individual states, what would southern states, for example, do about civil rights? Would they have passed civil rights bills? And he says the answer is no. He says you need a strong national government because only they can tackle problems like racism. All right. Now, in the 1980s, Reagan proclaimed a new federalism as the basis for attempting to dismantle social welfare programs. And Reagan said he wanted to restore the balance between levels of government. And he said federalism was thus employed as a basis for cutting many federal programs. So, for example, Ronald Reagan and Republicans believed that giving states powers back was the best way to go. And one of those things was to get rid of, for example, national welfare programs. So, for example, say something like food stamps. It's not that conservatives wanted to get rid of food stamps altogether, but who do they think should be responsible for doing that? And Ronald Reagan and Republicans say, hey, ultimately it should be the national government, not the national government doing that, but individual states. Like, for example, if West Virginia wanted to have a food stamps program, then it should set up its own program. But if Arizona doesn't want to have a food stamps program, that should be up to them. All right? And so the author says, look, we need a national government with a lot of authority, broad authority. Okay? And he says, hey, I'm different because my view is in sharp contrast to the conservative vision of federalism. So he's telling you, hey, I am different than the conservatives on this issue. Okay? Meaning that he's a what? He's probably more liberal. Okay? So he says, look, we need a strong national government to tackle problems like minimum wage, protecting consumers, child labor, segregation, and racial issues. All right? So let's take a look at this next one here. Okay? Constant exposés by journalists, labor, and progressives showed the great harm created federal pressure for action. All right. And if you remember things, for instance, like the book The Jungle by Upton Sinclair, okay, journalists and other other people involved in labor showed how bad working conditions to be and how child labor was essentially an issue. So the federal government got pressured to do something about it. All right. In 1960, Congress passed the Keating-Owen Act, which prohibited interstate commerce of any merchandise made available by children. From the perspective of social policy, it's impossible to imagine opposing such a law. And so, what he's saying is, hey, this author says, look, everybody, pretty much everybody, says it's a good idea to prevent child labor. Okay, and it says, hey, nobody really seriously thinks that kids should be doing a lot of this dangerous labor in factories, right? So we'll put like here a commentary on this that uh, everyone pretty much agrees that child labor is bad and there ought to be a law banning it, right? But the real question is this: who has the authority to ban child labor? Is it the national government or the states? And here's what happened, okay? He says, look, but in Hammer versus Degenhardt, the Supreme Court declared the law unconstitutional on federalism principles as a violation of the 10th Amendment, right? The court did not question that Congress had the authority to regulate shipments in interstate commerce, but it said this power could not be used to control production and ban child labor. It's a highly dubious conclusion. There's nothing in the text of the 10th Amendment and anything in its history that applies that it's socially undesirable. Okay, so he's saying, look, in this particular Supreme Court case, all right, the Supreme Court sided with states, saying, you know what, this law up here that prohibited child labor, right? The Supreme Court was wrong about it. He's saying, hey, that was a bad decision. Okay, that's what he means when he says it's a highly dubious conclusion. All right, and he says, look, man, everybody in the country agrees that we should ban child labor. Okay, so why is it that the Supreme Court says, oh, well, it's not in the Constitution, therefore states should be making that law? Okay, And it says, look, the practical problem with the court's approach to leave this to state authority was that economic pressure from states did not prohibit child labor. Okay? And it says, look, if you leave this issue of child labor up to the states, here's what's going to happen. Okay? States that wanted to outlaw child labor would find it difficult to have their businesses be competitive as long as other states allowed it. For example, let's say that West Virginia really wanted to ban child labor, but we can't compete with businesses from Ohio because Ohio won't ban child labor. All right. And it says West Virginia would be economically pressured. Okay. Right. And so he's saying, look, it'd be nice if we left it up to state authority. The author says, hey, it's nice sounding. And you know what? I get it. The 10th Amendment says that if it's not in the Constitution, it belongs to the states. But the real issue is that unless everybody gets rid of child labor, there might be states who would simply not do it and they would have a competitive advantage. Okay? And it says economic pressures realistically limited state choice as much as any federal regulation. All right? And so we'll put that here that states would feel pressured to follow policies of neighboring states who had economic advantages. Let's put it into another context. What if we let pollution, what if we said pollution, air pollution was something, or water pollution that would be left up to the states and not the federal government? People would feel pressure because the only states making money would be the ones who allowed pollution. Okay, let's take a look at a second issue. So he says, look, the Supreme Court said that the federal government shouldn't be the ones banning child labor. All right. Well, this guy says, hey, you know what? State authority is all nice and everything, but it's not realistic because states are going to feel that pressure to compete with other states. Okay. This next issue, he says, look, in Carter versus Carter Coal Company, the court declared unconstitutional the Bituminous Coal Conservation Act. The law contained detailed findings as to the relationship between coal and the national economy, and that the production of coal directly affected interstate commerce. The law provided for local coal boards to determine coal prices, and after being bargaining with by unions and employers for wages and hours for employees. Okay, so this law said that there would be local coal boards who would figure out what the prices were for coal and determine what the wages and hours were going to be. So ultimately, they're like, hey, this law would say that coal companies and unions and employers, unions and employers would all work together to figure out the best possible wages and hours for everybody, and then everybody would be happy. All right. But the Supreme Court said this law is unconstitutional. Okay, because it doesn't give states the authority that they deserve. And what this author is saying is, hey, the Supreme Court said, hey, this is once again where the Supreme Court's going to mess up. All right. And the court said this narrow definition of the Commerce Clause was essential to protect states. And it says, look, the Supreme Court ruled in this case with the coal company saying that law was unconstitutional because the national government doesn't have the authority to make laws about the production of coal. The production of coal itself is not interstate commerce. Okay, the transactions involved with it are a different story, right? And he says, look, I know that they probably gave the right interpretation, okay, but the problem with that is it doesn't account for the overall good of the economy. And notice that here's what the court's rationale was in that case. All right. It says the court emphasized the narrow definition. It lamented every journey to a forbidden end begins with a first step. And the danger of such a step by the federal government in the direction of taking over powers of the states is that the end of the journey may find states so despoiled of their powers, so relieved of their responsibilities that they are just geographic subdivisions. And he says, look, the Supreme Court doesn't like giving the national government any additional authority because they're afraid of what the Anti-Federalists were afraid of. That if you start chipping away at state power, then ultimately you're going to leave the states as a geographic, like a little subdivision. It's not really empowered to do anything, right? And notice that this section says violating the Constitution, but for a desirable outcome, all right? And it says, look, in both these situations, in laws about child labor and in laws about the coal companies, that these were laws that ultimately the Supreme Court they ruled correctly in saying that the federal government probably overreached. But is that the best outcome for everybody? Because, is it the best outcome that the national government can't deal with child labor laws? And this author's saying, no, it's not. Is it the best outcome that an agreement or a federal law which would allow unions and employers to work together to negotiate labor prices and labor hours, is that, even though it might violate the Constitution, is that not the best idea? All right. So he's saying, hey, maybe if you violate the Constitution, that's not such a bad thing. All right. If you get a good outcome from it. All right. Now, let's go to this last section here. Okay. Federal intervention. And this part says federal intervention will serve the greater good. All right. And what he's saying is, hey, with this little section here, he says the federal government having more authority is a good thing because it helps society. And he says, look, from 1937 until 1995, not one federal law was declared unconstitutional on the grounds of exceeding the scope of Congress's power. All right. So he says, look, from 1937 all the way to 1935, the Supreme Court did not rule the federal government was overreaching. All right. The Supreme Court broadly defined the scope of federal authority to deal with national problems and rejected that the 10th idea reserved a zone of activities for the state. This is a progressive vision of federalism was the law, meaning that, look, all throughout this time period, anytime there was a controversy about who had the authority to do something, whether it be the states or the national government, the Supreme Court always took the side of the national government, and that's a progressive vision of federalism. And that's a good thing, okay? Now it says, notice again that each of these laws and these cases is unquestionably desirable. The court should return to the approach of federalism that it allowed in that time frame, right? Congress should be able to regulate under the Commerce Clause as so long as there's a rational reason for believing that an activity has a substantial effect on interstate commerce, right? So this guy says, look, the national government needs more authority so we can get good policy outcomes. Because he says, hey, you don't want child labor. Well, you know what? Give Congress broad authority under the Commerce Clause, okay? And if you're thinking at some point, you're like, gee whiz, that's probably not a good idea. Maybe you're right about that, right? So this guy's saying, look, the U.S. government, the federal government, should have broad powers under commerce so we can achieve important, or let's put it this way, so that we can pass important laws that should apply to every state, right? So this author's saying, hey, the national government should have way more power than what we give it now, okay? And he says, my critics will invoke the importance of state government, but the structure of state governments is a means to an end, the effective governance promised in the preamble, and not an end to itself, okay? Defenders of federalism argue that dividing the powers vertically among levels of government is a way of checking authority and decreasing the possibility of tyranny, okay? And that's true. That's one of the things that people often argue. And he says, I know I have my critics, okay? That the preamble, though, promises effective governance. You remember the preamble to the Constitution. It says, provide for the common defense, promote the general welfare. And he says, if we're going to do that, if we're going to achieve those goals in the preamble, then the national government has to do a lot more than what it currently does. And he says, you know what? Ultimately, I don't think it's going to be a tyrannical government. If anything, he says, history shows us that it's not tyrannical. Ultimately, I believe the progressive vision of federalism as empowering will do a much better job of fulfilling the preamble's goal than the conservative approach using federalism to strike down those laws. I have no doubts that this will be important in the years to come as conservatives turn to federalism to strike down laws concerning civil rights, consumer safeguards, and environmental protection. Right? He's saying, look, you ultimately have to look at this from the perspective of what's best for the country. And he says the preamble to the Constitution says that the national government should be effective in what it does. It should be promoting the general welfare, establishing, a more perfect union. And he says if we want to do that, if you want to achieve the preamble's goals, all right, then you need to give the national government broad power. And he says that broad power can come from the Commerce Clause. Because if you go strictly by the 10th Amendment, then he says civil rights laws, for example, right? We have laws in place that, for instance, say you can't discriminate against people on the basis of their race, their sex, or their ethnicity. And he says if you left that up to states, like through the 10th Amendment, they would never do it, that they would never get it right. Consumer safeguards, like we mentioned, for instance, the Food and Drug Administration. If you let states regulate food and drugs, then they wouldn't get the protection. Some states would want an economic benefit, so they wouldn't be as harsh on producers as perhaps they ought to be. And environmental protection. If you left that up to individual states, he's saying you'd get screwed. He's like, you would totally get screwed because there would be some states, the more conservative states, like say like an Arizona or a Texas, who they wouldn't give a crap about environmental protection. They would take things out of the ground and not worry about the environment. Okay? And so what he's saying is overall, he says we need a stronger national government. All right? And he says the best way to do that, the best way to give the national government the power it needs is it should be interpreted under the Commerce Clause. Okay? And it says the Supreme Court broadly defined the scope of federal authority in this time period in 1937 and 1935, meaning we need to use that again. Because he said during that time, the Supreme Court almost always sided with the federal government. And the fact that he said we should be able to do a lot under Commerce Clause as long as it even remotely has an effect on it. So, for example, making laws about, like, let's say, something that came up last year, the Fairness Act, the LGBT protections for the LGBT community. Okay, and he says, look, if all you need to do to make that law is to have some type of link to interstate commerce, and ultimately we should allow for a broad interpretation of that. Okay, and people, by the way, for the civil rights laws from 1964, which dealt mostly with African Americans, that's how they rationalized it, saying that the Civil Rights Act affected interstate commerce. Okay, is that a bit of a stretch? Yeah, but this guy who wrote this book, Erwin Chemerinsky, which is an incredible name, uh, he specifically is saying, I don't mind stretching the Commerce Clause because it's going to help the country. All right. And so ultimately now use that as a means to help you answer these questions. And hopefully this will help you along the way. It's a long explanation. I know this video is a little longer than what you would have wanted it, but we need to do this because we don't have time for it in class. We're still behind a little bit, but if you have more questions, please let me know. I appreciate you guys who specifically reached out and said, hey, I need some help with this, and I just feel like it's a bit much. Once again, if you got more questions, let me know.